So, good afternoon, colleagues. I'm Sarah Ward. I'm the Principal Advisor in the Workforce team at the LGA. Today's session on exit payment reform, or the 95k cap, and the MHCLG consultation on further reforms is being brought to you jointly by the LGA Workforce and Pensions teams. We've been following this issue really closely and have provided guidance and explanations to all our stakeholders throughout. We've also been talking to several government departments, ensuring that we help shape things, which is always based on our shared knowledge and experience. So we'll share what we can with you today. Don't forget, we have a website with loads more information on there, which we've been keeping up to date throughout the whole of this consultation process. For many of you, you might have joined us on one of these webinars before. This is our third webinar on this topic. But as previously promised, we're aiming the information today specifically at non-local authority employers who are covered by the cap. So some of you are obviously going to be from local authorities, and some of you maybe, but will also be advising such bodies. But I know we've got various people joining us today from academy trusts, from police forces, fire and rescue services. So wherever you are from in the LGA family, you're all very welcome, and thank you very much indeed for joining us this afternoon. So everything that we're going to say and share today is up to date and absolutely true at the point that we say it. And indeed, some of the info that we'll share is genuinely hot off the press. I hope I'm not making this sound too exciting. But you'll appreciate there are going to be some areas where there are, additional bits of information that are still needed, but the speakers will flag that to you as we go along. So as you follow the slides, people will say, this is where we are, and we'll flag if there's any areas of uncertainty. We will, of course, share the slides following the webinar. We always do, but please just bear with us on that. We will get that up as quick as we can, but it just has a little bit of technical and logistical challenges. So as soon as we can, we'll get those up. Just a couple of points on logistics before we bring in the speakers. The chat function is disabled, and that's because we want you to use the Q&A function. So we obviously want you to post your questions in the Q&A box. You can upvote as well and indicate if somebody else has already asked a question that you really want to hear the answer to. So do make use of that. And we are aiming to finish this webinar at 1:30, but what we will try and do is cover off as many questions from the Q&A box at the very end as we can. So let me just take you through the format today. We are going to have a couple of presentations to start with. We're starting with Naomi Cook, the Head of Workforce. Naomi is going to take you through the cap, a little bit of history, cover off a bit about the waiver process. Then we're going to hand over to Jackie Wood, who's a pensions advisor, and Jackie is going to talk us through some of the issues in relation to the teachers' pension scheme. After Jackie, we'll be bringing on Rachel Abbey, who is also a pensions advisor, and Rachel's going to talk us through some of the LGPS considerations. You will be pleased, I think, at that point to have a small pause from PowerPoint, and then we'll have a little bit of what we're now calling a fireside chat. We'll be bringing in Jeff Houston, the LGA Head of Pensions, and Phil Bundy from the Employment Relations Unit. And we've got some questions already that we'll put to Phil and Jeff at that point on the issues that we've covered on the webinar thus far. Once we've done that, we'll go back into another presentation from Rachel. She's got some more slides to take us through. And then at the end, we'll bring Jeff and Phil back, and then we'll throw anything at them from the Q&A box that hasn't yet been covered. So I hope that sounds like a plan. I hope that's given you time to settle in. I hope that's given enough opportunity for all the participants to join us. Good luck with your technology, everybody. We always are a little bit in the hand of fate there, but hopefully this will all work out and that the Wi-Fi will be kind. With that, let's get our show on the road, and I'd like to welcome our very first speaker today, Naomi Cook. Naomi.
Good afternoon, everybody. As Sarah said, I'm Naomi Cook, the Head of Workforce at the LGA. And I'm going to start off with setting out where we are at the moment with exit pay changes affecting those in the wider local government family, including schools of all types and others covered by the local government pension scheme. So we have two topics for today: 95k cap and the MHCLG consultation. To be clear, what we're outlining today is based on what we know at the moment and what has been conveyed in writing to us. For reasons we will explain around legal challenges to the legislation and its implementation, and due to some confusion in the guidance from relevant government departments, there remains significant uncertainty about how employers should proceed. This webinar then relates to employers other than councils who are affected by the cap and how it in turn applies to local government and related pension schemes. So the agenda for today covers two main themes: 95k cap and implementation of further changes. So with preliminaries out the way, let's summarise how we got here. Firstly, the 95k cap. Initially proposed more than 5 years ago, the legislation was finally enacted this year and became law on the 4th of November. So aside from ill health cases, no one in the public sector, the definition of that is complicated and we'll come back to that, can receive an exit package of more than £95,000. Now, an exit package includes the amount of money an employer would pay into a pension fund in order to fund unreduced early access to pension. This is known as the strain payment, and in local government is generally the major part of an exit payment for people aged 55 or over. Now, there's been changes to employer national insurance payments on exit payments a couple of years ago. So since the original policy was announced, but before the legislation came into place. However, this adds to the complexity because so far, despite many requests, HM Treasury has been unable to confirm that employer national insurance does not count as part of the 95k. So unfortunately, this is one of the several reasons that we'll be outlining in this webinar, why we would strongly urge you to take legal advice when determining what exit payment is relevant in your particular situation. There are other reasons that you'd need to check around whether payments must be paid or whether they're employer discretions. All of these you would need to be certain of when approaching decisions around the cap and potential waivers. So moving on, MHCLG, the Ministry for Local Government and the responsible authority for the local government pension scheme, launched a consultation earlier this year to change the pension rules and compensation rules for local government. Their proposals will amend pension scheme rules in order to allow the 95k cap to apply and to enable members to have greater choice about whether and how they take their pension if they're subject to the cap. However, it should be noted that MHCLG's proposals go beyond pension provision alone and do in fact set out further reforms that would limit the amount of severance cash an individual can receive. These plans were issued by Treasury 4 or so years ago for the whole public sector to implement, but as yet no other part of the public sector has successfully done so. However, we understand that Department for Education now also plan to consult on wider reform proposals at some point in 2021. And like the MHCLG consultation, this will propose changes to the teachers' compensation regs in line with the Treasury proposals from 2016. So back to whom is affected by what. Now this should be a relatively simple question, but is made more complicated by inconsistent coverage between the exit cap regulations themselves and the forthcoming reforms to exit payments. And now, as befits the task faced, we have co-opted the spirit of the Olympic rings to try and explain the landscape as it's currently understood. As some of the regulations are still in draft, of course, there is the potential the situation could change. So please, before embarking on any workplace reform that might include redundancies or exits, it will be worth you checking what applies. Also, to be aware, this relates to England only at this stage. We'll discuss the situation in Wales separately as different provisions apply. To start with, the green circle, those who employ teachers, so we're looking at academies and maintained schools, for example. Then we have the red circle, those covered by the 95k cap regulations. So maintained schools again, but also fire services, police, councils, etc. And then the yellow circle, those covered by the LGPS and its related redundancy compensation provisions. So support staff in schools, fire and police services, councils again, and some outsourced service providers. So as you can see, there are some overlaps, but not a great deal of synergy between these categories. We do, however, understand that MHCLG are seeking to effectively move the yellow circle within the red one, and the outcome of their consultation on reforms might reflect this. Again, though, I know I'm standing like a stuck record, but to be sure, before embarking on any exercise that might include redundancies, please check which regs apply to you. Now, should the employer wish, there are two routes to waive or relax the cap for particular exits. The reasons the cap can be waived are the same across employers and are set out on this slide. So firstly, a mandatory waiver, which can be sought in certain cases where an employment tribunal would, in the employer's view, having received legal advice, make an award that breaches the cap. Secondly, there's a mandatory waiver where redundancy provisions are protected under TUPE rules. However, as worded, this provision does not seem to cover TUPE-like transfers, such as machinery of government changes, and so again, employers in that situation will want to take legal advice on their options. A discretionary waiver is an option in 3 circumstances, although it seems likely that it's the second of these 3 that will be of most relevance. Briefly, the 3 types of cases that can be considered for a discretionary waiver are undue, sometimes referred to as genuine hardship of the individual or their family. There's no definition of hardship, but Treasury have been clear that they view this as very unlikely to occur in practice. Secondly, where workforce reform would be inhibited. We expect this to be the main route pursued by those looking for a discretionary waiver, and will necessitate the provision of information on the value for money case and the objectives of the workforce reform being undertaken. The third option is set out on this slide, and we believe was intended to act as some sort of transitional provision, but it doesn't really fulfill that purpose and will have very limited application. So, if an employer has a case for a waiver, how do they access it? In the case of a mandatory waiver, the employer must submit a business case to their sponsoring employer for approval from the Permanent Secretary and Minister. The regs are reasonably clear that it's the sponsoring department of the employer who should make the approval decision, although there is some confusion between Whitehall departments about how that interacts with the responsible authority for the purposes of pension scheme coverage. Yesterday, MHCLG published some guidance around their processing of waivers for English employers who are members of the LGPS. And unfortunately, that hasn't really clarified the role of the department so much as confusing it further. However, we are hoping that that will be sorted out soon. And assuming it is, the process for mandatory waiver is relatively simple. And I can say that because it's the process for discretionary cases that's rather more convoluted, as in addition, Treasury needs to approve these waivers. So the employer needs to put a business case to their sponsoring department, and if they approve it, put the case again to Treasury. Employers will therefore want to factor in a fairly considerable period of time for a waiver decision before making any firm decisions or offers to individuals. And remember, without a waiver, an employer may not pay an exit payment of more than £95,000. So as we understand it, and as I say, the civil service is still working this through, this slide outlines the process for different employers utilising the mandatory process, as set out in the written regulations. If your situation isn't covered here, please let us know in the Q&A and we'll make our best estimate of the likely process. And as I mentioned, in particular, we'll go through the situation in Wales in more detail later on. So for the discretionary process, as you can see here, there is an extra level. Add to the lack of certainty over what needs to be in a business case and potential follow-up questions at each stage, and this could take a while. The process set out here is taken from the guidance from Treasury. However, you should be aware that there are question marks over whether individual government departments will follow this in full, as reflected by the MHCLG guidance. and also whether the status of the Treasury guidance itself remains, given some of the issues that have been raised in judicial reviews that are currently in progress. Relevant employers should be aware of the MHCLG guidance, although the LGA has raised a number of issues with its content, and we will go into that in more detail later on. And just to be clear, the waivers only apply to the 95K regs. There are no waivers for the further reforms that we'll outline. But first, I'm going to hand over to Jackie to take us through the effect of all this on the teachers' pension scheme.
Thank you, Naomi. Good afternoon, everyone. I'm Jackie Wood. I'm a teachers' pensions advisor at the LGA. So I'm going to run through the next few slides, which are about the impact of the exit payment cap on the teachers' pension scheme. So the current position for compensation under the teachers' pension scheme. The teachers' compensation for redundancy and premature retirement regulations set out the compensation that can be awarded by employers in scope of the regulations. So for the purposes of this webinar, a teacher in an academy is covered by the regulations. A key point to note is that compensation awarded under the regulations is at the discretion of the employer. We would expect employers to exercise their discretion in line with their agreed policy. And any compensation awarded under the regulations is now subject to the 95K exit payment cap. So I'll now run through the compensation regulations. Where a teacher, and this includes a teacher who's not in the teachers' pension scheme, is being made redundant, employers have discretion to pay discretionary compensation for redundancy. So this allows an employer to base any statutory redundancy pay on a teacher's actual week's pay if the actual pay is higher than the statutory pay limit, which is currently £538 per week. Where a teacher, including a teacher who is not in the teachers' pension scheme, is being made redundant or leaving in the interest of efficiency, employers have discretion to pay discretionary compensation for termination. So this allows an employer to make a lump sum compensation payment of up to 104 weeks' pay. This would include any statutory redundancy payment and any increase in the redundancy payment that's been made. The total must be capped at £95,000. So where a teacher who's being made redundant or leaving in the interest of efficiency is a member of the teachers' pension scheme and aged 55 or over, the employer has discretion to award premature retirement compensation. So there's two parts to premature retirement compensation. The first is mandatory compensation, and this is where the employer pays for the member to receive immediate payment of their pension benefits without a reduction for early payment. The second is discretionary retirement compensation, and this allows the employer to award an extra period of service to enhance the pension benefits. So where an employer agrees to pay premature retirement compensation, the employer must pay mandatory compensation. So the teachers' pension scheme will pay an actuarially reduced pension and lump sum based on the member's pensionable service, and the employer will pay the balance so that the member receives unreduced benefits. And so in the LGPS, this is known as strain costs. The member will receive unreduced benefits for their lifetime. A member who receives mandatory compensation for premature retirement can also receive discretionary compensation for termination. So an employer can use the actual pay rather than the statutory weekly limit in the calculation of redundancy pay, but they cannot make a lump sum payment of up to 104 weeks. The cost of awarding mandatory compensation is included in the calculation of the 95,000 limit for the cap. An employer has discretion to credit a member with an extra period of service, which is subject to certain limits. The cost of awarding extra service is also included in the calculation for the 95,000 limit. So I'll cover how you calculate the cost of premature retirement compensation in the next slide. So now the 95K cap is in force, the payment of discretionary compensation for redundancy, discretionary compensation for termination, and the cost to the employer of premature retirement compensation are all exit payments that are subject to the 95k cap. The Department for Education will be providing guidance for employers to explain how to calculate the capitalised costs of premature retirement compensation, to assess against the 95k cap, and what action should be taken by employers if there's a breach. So we understand from the department that employers will need to follow the following process. Employers will first need to find out the capitalised costs of any premature retirement compensation. Guidance is to be added to the Teachers' Pensions website to estimate the capitalised costs, but the final figure may have to be requested from Teachers' Pensions. Employers will need to assess the total value of any exit payments, and exit payments subject to the cap are set out in Regulation 5 of the Exit Payments Regulations. So if the total value is more than 95,000, employers will then need to consider whether to apply for a waiver, and Naomi's already talked about waivers. So if a waiver is not applicable or refused, premature retirement compensation will not be payable, and instead a cash alternative payment should be made under Regulation 8 of the Exit Payment Regulations. This payment should equal the capped capital value of the compensation. This would be dependent on an employer's policy and whether it's been changed to comply with the 95k cap. So what's happening in 2021? The DfE will be consulting on changes to the compensation regulations in the new year, with revised regulations expected to be coming into force in the spring. We understand that the regulations for discretionary compensation for termination will be amended in line with HM Treasury proposals set out in 2016 and mirror the equivalent changes in local government, limiting discretionary compensation for termination to a maximum of 3 weeks pay per year of service, a maximum of 15 months salary. The actual pay used in calculations will be limited to 80,000. The regulations will also set out a methodology for dealing with premature retirement compensation where the value is more than 95,000. So I'm now going to hand over to Rachel, who will talk about the LGPS.
Thank you very much, Jackie. Good afternoon, everyone. My name is Rachel Abbey, and I'm a pensions advisor at the LGA, working on the local government pension scheme, or the LGPS. I'm going to talk about how the introduction of the exit payment cap will affect LGPS members. Just to be clear, this section is only about the exit payment cap that is now enforced. We'll be coming back later to the wider reforms that are being proposed by MHCLG later in this webinar. So I'm going to talk about the impact of the exit payment cap on redundancy and business efficiency exits that happened from the 4th of November onwards. There is currently a conflict between the exit payment cap regulations and the LGPS regulations. I'll talk more about this in detail and cover what you as employers need to think about as we go through the slides. So I'm first going to talk about, I'm generally going to be talking about redundancy exits. Most of the rules are the same for business efficiency exits, except that statutory redundancy payment is not generally payable in those cases. And that'll be the case for all the examples today. I'll talk about redundancy, but most of the rules will also apply for a business efficiency exit. So I'm first going to look at employees who are not entitled to the immediate payment of their pension when they're made redundant. So this will include those employees who are eligible for membership of the LGPS but have elected to opt out of the scheme, and employees who are LGPS members but are under age 55 on their termination date. Before the exit payment cap was introduced, so up to the 3rd of November this year, these groups were entitled to a statutory redundancy payment, which is based on the employee's weekly pay, capped at £538 a week. The employers may also have a policy to pay more than the statutory payment. They can base the payment on the employee's actual weekly pay, if this is more than the statutory maximum of 538. They can also pay discretionary compensation of up to 104 weeks pay, including that statutory payment. In addition, those employees who are LGPS members will also qualify for deferred pension benefits. They can then take that pension at any time between age 55 and 75. The pension would be reduced for early payment if they take it before state pension age, or increased if it's taken after the state pension age. For these members, there's very little has changed on the introduction of the exit cap from the 4th of November this year. The change is that the total compensation is capped at £95,000. In reality, we don't expect the exit payment cap to impact on these types of members very often, because it's very rare that scheme employers pay compensation that exceeds £95,000. Moving on to the more complex cases, these are employees who are in the local government pension scheme and over age 55 when they're made redundant. Before the 4th of November, this group would receive statutory redundancy pay, discretionary compensation in line with their employer's policy. The same upper limit of 104 weeks that I mentioned before would apply. They also must have taken immediate payment of their LGPS pension, and there is no reduction to that pension for early payment. The LGPS administering authority estimates how much it would cost to pay the pension early, known as the pension strain cost, and the employer funds the early payment of the pension by paying that strain cost to the admin authority. The calculation of the strain cost is decided locally by each administering authority based on local assumptions about life expectancy and other variables. Following the introduction of the exit payment cap, what happens to members in this group will depend on whether the total exit payments the employer planned to make to the employee and to the administering authority is more than the cap of £95,000. And it's important to remember that the strain cost is included in assessing whether that £95,000 is exceeded. For most cases, we expect that the total value of exit payments would be below £95,000. In this case, there is no change to the benefits paid to the member. They will continue to receive any statutory redundancy pay, discretionary compensation in line with their employer's policy, and they also must continue to take their LGPS pension immediately, but it wouldn't be reduced for early payment. These exits can continue to be processed exactly as they were before the cap was introduced, with the employer paying the full strain cost to the administering authority. If the total value of the exit payments is above £95,000, then there is legal uncertainty for both the employer and the administering authority. The uncertainty exists because the exit payment cap has been introduced, but the LGPS regulations have not yet been changed to accommodate the cap. So currently, the LGPS regulations still require the member to take payment of an unreduced pension, but the exit cap regulations prevent the employer from paying the full strain cost where it would exceed £95,000. As an LGPS employer that is subject to the exit payment cap, you have new responsibilities and decisions to make. So, what are an employer's responsibilities under the exit cap regulations? As I mentioned, the cap is most likely to be breached when an LGPS member leaves due to redundancy or business efficiency over age 55. When this happens, the employer needs to add up all the exit payments they would normally pay, including the pension strain cost, and check if the total exceeds the cap. If it does exceed £95,000, the next step is to consider whether a discretionary or mandatory waiver might apply. If an employer makes a successful application for a waiver, then the exit payment cap is waived and the £95,000 limit does not apply. As Naomi has already covered, the waiver process is complex to say the least, and this step may take some time, and it's worth getting information early from the administering authority about the cost if you are considering a waiver. If the employer doesn't apply for a waiver, or if their waiver application is rejected, the next step is to consider whether any of the payments can be reduced to bring the total cost down below £95,000. You must still continue to pay statutory redundancy payment, pension strain cost, and any other payments you're obliged to pay. You'll be looking to reduce any payments that are discretionary. If the new total is £95,000 or less, the member is still entitled to immediate payment of an unreduced pension. But if the total is still more than £95,000, then the employee is capped, and the conflict between the LGPS regulations and the exit cap regulations comes into play. The LGPS regs say that the member must take immediate payment of an unreduced pension, but the exit cap regulations prevent the employer from paying the full strain cost. So what should you do as an employer? First of all, you need to make sure that you communicate with your administering authority. They will need to know whether the member is subject to the cap, whether the total cost of the exit will exceed the cap, and whether you applied for a waiver. This will ensure that the administering authority can pay an unreduced pension when the cost of an exit is below the cap, and they can take the appropriate action when the cost of the exit will exceed the cap. If you fail to check the total exit cost and fail to keep the administering authority informed about the member's status under the exit payment cap, this could lead to a breach. If the member is capped, you will need to decide if you're going to pay a cash alternative payment that Jackie touched on a moment ago. In the longer term, the LGPS rules will be changed to allow the payment of a partially reduced pension when the cap means that an employer cannot pay the full strain cost. Until that change is made, the exit cap regulations say that the employer must instead pay an additional cash alternative payment to the employee. The total of all exit payments, including this cash alternative payment, will be capped at £95,000. Remember, income tax and employers' national insurance are payable on termination payments that are above £30,000. A capped employee can choose either immediate payment of a reduced pension or a deferred pension, which they can take at a later date. The government believes that the exit cap regulations take precedence over the LGPS regulations. This means they believe that the employee's right to the immediate payment of an unreduced pension falls away when the cap is breached, and that the employer must pay the cash alternative set out in the exit cap regulations. The Scheme Advisory Board to the LGPS has taken its own legal advice. We think it's highly likely that an employee will make a legal claim if they don't receive immediate payment of an unreduced pension when they are made redundant over the age of 55. At the moment, the LGPS regulations say that they are entitled to an unreduced pension. According to the legal advice that SAB obtained, there is a high risk that any such legal challenge would be successful. One reason that such a legal challenge is likely to be successful is that there is no direct link in the LGPS regulations between a member's right to an unreduced pension and the ability of an employer to pay the strain cost to fund that pension. So what do you do as an employer? Our recommendation is that you defer payment of the cash alternative until the conflict in the regulations is resolved. The conflict is only likely to resolve because of a legal challenge being launched. If instead you do decide to pay a cash alternative now, you need to be aware of the potential implications of doing so. The employee could end up with a full pension because of a successful legal claim. If that happens, you'll be asked by the administering authority to pay the strain cost up to the level of the cap to fund payment of the unreduced pension. If you have already paid a cash alternative, you'll be in the position of either having to try and recover the cash alternative payment from the employee, or you end up paying twice, once for the cash alternative and again as increased scheme costs. If the employee makes a legal claim that is not successful, they may prefer to have the cash alternative paid to the pension scheme to buy extra pension rather than receiving it as cash. So again, another reason not to make the cash alternative until the legal dilemma is sorted out. So to briefly summarise, if the cap is breached, there is a conflict between the two sets of regulations, the LGPS and the exit cap regulations. Each employer needs to decide what course of action to take in relation to the cash alternative. Our recommendation is that you delay payment of the cash alternative until the situation regarding the pension is clear. We believe this approach provides you with the most flexibility and presents the least financial risk to you as an employer. You can find links to the legal advice that the SAB obtained and SAB's commentary on that advice on the board website, which is lgpsboard.org. That's all from me for now. I'll pass back to Sarah and the panel to cover some questions.
Thank you so much for that, Rachel. So much information there. Thank you to all the speakers so far, to Naomi and Jackie too. We will be bringing Rachel back in shortly, but we've got a few questions that we're going to put first of all to, as previously flagged, Jeff, the Head of Pensions, Jeff Houston, and Phil Bundy from the Employment Relations Unit. And what we've got a couple of issues we already wanted to make sure that we put in front of you, but obviously there's been a couple of questions in the chat that I think we can quite quickly cover here as well. So Phil, I'm going to come to you first of all just to ask you about Ian Thompson's question about police authorities. What would be the relationship now between the PCC, Chief Constable, and the Home Office? Can you just cover off that one for us?
Yeah, I think this was in the context of the waiver slide where it referred to a police authority, whereas actually what it really means there is the police employer, because it's the employer that actually applies for the waiver. So in many cases that will be the Chief Constable, in some it will be the PCC. So that is the relationship there. They apply to the waiver, and the expectation is that that would sit within the Home Office as a police body.
That's really helpful. Thank you for that, and we'll bear that in mind as we go forward. And Jeff, really quickly, I think this is a straightforward one for you from Lynn about ill health retirement, whether or not that's subject to the cap.
The answer is no.
Well, there you go. I did suggest that that might be brief. Thank you, Jeff. So, Phil, back to you about national insurance contribution payments. Do they count towards the cap?
Yeah, it's been mentioned a few times in employers' national insurance contributions. These are 13.8% on payments above 30,000. So we're talking about a fair amount of money. And the question is whether they fall within the definition of an exit payment for working out whether you've got to 95k. And when you think about it from one perspective, you think, well, actually, this is money that the employer's paying, but to the taxman. So it's staying within the public purse. So why should it fall within the 95k cap? But then when you actually look at the regulations, an exit payment is defined as something that's in connection with someone's exit, and it doesn't have to be made to the individual itself. It could be made to another body. So on the face of it, if you're looking at the regs, employer NICs do fall within the cap, but we have asked the Treasury repeatedly to tell us whether they consider these fall within the cap, and we're still waiting for an answer. But when we do hear, we will confirm the position on our website.
Thank you, Phil. I should just very quickly say as well, another question I just picked out of the chat was about the slides. They'll go on our website, the slides. Phil's just mentioned the website as well. So that all the slides will go up there. And I said right at the beginning, we'll get those up as soon as we can. I know there's a lot of information on all of this, so we'll carry on writing our briefs and getting stuff out to you. A couple of questions now I'm going to put to Jeff on the waiver. So Jeff, the first one is, what are the main points in the MHCLG guidance on the waiver, and what are the issues with it that you've raised with MHCLG?
Yeah, thanks very much. So as Naomi said earlier, we were hoping that the MHCLG guidance might give us some clarity. Unfortunately, that's not quite the case, and there are quite a number of issues that we've raised about that going forward. For example, it talks about what grounds which you can waive things on. The HFT guidance talks about particular kinds of grounds. For example, it talks about urgent reforms in terms of workforce reforms. Instead, the MHCLG guidance, and I just want to make sure I get this right, it talks about that not exercising the power would significantly inhibit workforce reform. Now, I don't know if that means the same as urgent, and we are trying to find out if that means the same as urgent. There's a lot of issues within these waiver reforms. We're hoping to get clarified. We're hoping that the MHCLG will come forward with an FAQ where we can take some of these points as we go forward. But there's a number of points there that are currently within that guidance that we think just add to the confusion rather than make it clear going forward. So we've raised a couple of those in particular. So there's one in particular that talks about publication of data. We've raised a question on there that the list that they've included might include some personal data. So I spoke to MHCLG this morning and said, presumably you want us to act within the provisions of GDPR, and they did confirm that that was the case, regardless of what that list says. So yes, we will be making sure that everything you publish is within GDPR. And in there, they talk about the administering authority quoting the capped strain costs, when for all of the reasons that we just talked about already, it's very difficult for an administering authority to do anything but actually quote the full strain cost, because it's for the employer to then think about how much of that they can actually pay. And then finally, we're moving on to who you should apply to a waiver for. What we put out on the slides is what's in the guidance at the moment. As Naomi said, we understand discussions are continuing across departments, and we understand that situation might change. So for example, we think that with regards to schools, DfE might want to see all the waiver requests, regardless of which particular pension scheme. So whether it's a teacher or a non-teaching staff, whether it's a maintained school or an academy, all to go to DfE. Whereas for uniformed, it might well be that Home Office only want to see this in terms of the waiver requests for uniformed staff, whereas for non-uniformed staff, that to go to MHCLG. But we will confirm that as soon as we know more.
Okay, thank you, Jeff. That wasn't one of the quick questions, as you will have noticed. Coming back to you on waivers, though, obviously the slides thus far, we dealt with English employers. So what differences are there in Wales?
This is going to be a slightly quicker answer, thankfully, but potentially not a more helpful one. The waiver process will be different in Wales. So effectively, the Welsh Government takes over the role of HMT in Wales. So Welsh Government will decide on the criteria, they will decide on the process, and they will make the decisions as to whether waivers are granted. We still don't know exactly what the process is going to be, but it will be significantly different in Wales.
Thank you for that. Okay, Phil, I'm coming back to you now just to pick up some TUPE issues. Firstly, just to ask you about how the TUPE waiver will work and what will happen when someone transfers under TUPE from a capped to a non-capped employer.
Yeah, well, the TUPE waiver, it applies only when there's a transfer under the TUPE regulations itself. So sometimes in the public sector, you get TUPE-like transfers, not actually under the regs itself. That will typically happen where you get sort of wider local government reorganisation. So the first thing to check is whether you've got the TUPE transfer itself. That will normally be the case, say, where a school goes into an academy situation. But then you need, of course, to check what's actually transferred and whether that will be protected under TUPE. And a lot of the time, these sort of benefits that are transferring are discretionary. They are not contractual. So actually, there isn't a benefit that is protected that the employee can point to and say, you've got to pay me that. It's protected under TUPE, so the waiver wouldn't apply in that case. And then the sort of final case where someone, or where the final part of that question is where we're looking at where someone transfers from a capped to a non-capped employer. The short answer to that is that the cap will not apply in that non-capped employer, so the employee will get above 95,000. There is a proviso to that, though. The cap might apply through the back door. And the reason I say that is quite often before the transfer, the capped employer may have amended their policies, their contractual provisions to provide that no one gets above 95k. So it's that is what will transfer. And so in effect, that is a capped benefit through the back door.
Goodness, thank you for that, Phil. I just wonder if I can put you on the spot, and this might be the last time that we work together if this isn't a welcome question, but somebody has put in the Q&A box about implications for anybody who's over 55 after TUPE. I don't know if you've had a chance to look at that question.
Yeah, I think this is going to come down to, I think, how the pension regulations are amended. And I think if the amendment applies to the employee that they TUPE into, then the cap would apply. But if the cap doesn't apply to that new employer and the pension regs haven't been amended in that way, then the cap doesn't apply. But it's complex. Whenever you get into pensions and TUPE, there you go.
It is. That's why I like to leave it to you. Brilliant. Thank you for having a really great stab at that question. In any case, I think that's really helpful and shows the complexity. I'm really quickly going to ask Jeff just to comment on the LGPS regulations change. Any view on the timeline of that? When do you think that might happen?
Well, we were hoping, and I think Rachel might touch on this, but not wanting to steal her glory, we were hoping that we might see NHCLG regulations in January. We won't.
Yeah.
There are judicial reviews underway. Spoke to NHCLG this morning. Their ministers are minded to wait to see how those judicial reviews go along. So I think it's probably going to be March, April now before we see these regulations.
Right. Okay. Yeah. Okay. So spring probably at best. Okay, I'm going to stop that section just there. Thank you, you two, just for the time being. I'm going to bring you back in later on. What we'll do now is we're going to go back to Rachel Abbey and just cover a bit of the further reforms from MHCLG. And then what will give us a chance to do is have a look through the Q&A box and see if we can group any questions or pick up anything very quickly at the end that you've put there that you want clarification on. So do keep posting in there if you've got other things you want to ask. And in the meantime, we will pass back to Rachel. Rachel.
Thank you very much, Sarah. As Sarah mentioned, I'm now going to cover the recent MHCLG consultation on further reforms to local government exit payments. The consultation proposes changes to the LGPS and compensation regulations to accommodate the exit payment cap that, as we know, is already in force, and to introduce wider reforms to exit payments. When the proposed changes are made, the conflict between the two sets of regulations, LGPS and the exit cap regs, that I talked about earlier will be resolved. When an employer cannot pay the full strain cost because of the exit payment cap, the member will be able to receive a partially reduced LGPS pension instead of the cash alternative. The member will also have other new options that I'll cover later on. Beyond changes to accommodate the exit payment cap, there are further changes proposed by the consultation. Firstly, to potentially limit the amount of discretionary compensation that employers can pay, and to reduce the amount of strain costs the employer can pay by any statutory redundancy payment that the employee receives. The consultation on these policies has closed, but MHCLG has invited comments on draft regulations by a deadline of tomorrow. As Jeff mentioned, we were hoping for changes in the LGPS regs in January to remove the legal uncertainty we're currently facing, but realistically, we don't expect any changes before the spring of next year. The draft regulations include some proposals for transitional measures. If those transitional measures are enacted, then these reforms I'm going to talk about will not apply to exits that are agreed before these regulations are changed if the exit occurs within 6 months of the date of that change. But having said that, you will need to be aware of these proposals when you're planning any sort of workforce changes for 2021 and beyond. So I'm going to look at the proposals for further reform in more detail, starting with employees who are not entitled to immediate payment of their pension, either because they are under age 55 or they're over age 55 and not in the pension scheme when they're made redundant. The proposed position is that these employees will still receive their statutory redundancy pay, but the amount of discretionary compensation will be limited. The maximum a scheme employer can pay will be limited to, and actually these are the same that Jackie covered before because they're the same limits that are considering it being introduced to the teachers' pension scheme. So a maximum of 3 weeks pay per year of service or 15 months pay, whichever is lower of those two, and a maximum salary of £80,000 being used to work out that payment. And also the exit payment cap still applies, meaning that the total cost must not exceed £95,000. Those employees who are in the LGPS, no change to them, they will also qualify for deferred pension benefits, which can be paid at any time between age 55 and 75, as currently. Moving on to employees who are in the LGPS and over age 55 on their date of redundancy. To recap the position before the 4th of November, a member of this type would receive statutory redundancy pay, discretionary compensation in line with their employer's policy, and they must have immediate payment of their LGPS pension, which would not be reduced for early payment. The employer pays the strain cost based on the local method of calculation to fund that early payment. The proposed position for this group, the MHCLG consultation proposes, first of all, a standard strain cost calculation, which will be used by all administrative authorities in England and Wales. This would mean that the exit payment cap and wider reforms have the same impact on members across the country. There'd be no local variation due to assumptions and calculation methods adopted by a certain admin authority. The standard strain cost is unlikely to be exactly the true cost, as it will not be based on the local experience. This will, of course, be picked up in the valuation process and could impact on employer contributions. It just depends whether that standard strain cost is higher or lower than the current strain cost used by your administrative authority, what impact that could have on employer contribution rates. The total cost of an exit, the total that an employer can pay, will be limited to the greater of the total strain cost or the discretionary compensation payment, which is calculated with reference to the new limits on weekly pay, total months pay or total weeks that can be used. And both of those are subject to the exit cap limit of £95,000. Just to be clear, these limits determine the employer cost only. I'm going to move on now to what the exit member will receive and the choices they will have to make. Looking first at a member who is made redundant over age 55 and the total strain cost is below £95,000. In most cases, the total strain cost will be more than discretionary compensation. If this is the case, when the strain cost is higher, the employer cannot pay any discretionary compensation. The total cost to the employer will equal the total strain cost. However, as a member being made redundant is entitled to statutory redundancy pay, the strain cost the employer can pay is reduced. So under this, the first option for the member, they can receive statutory redundancy pay plus a partially reduced pension. Just to be clear, under these new proposals, a member's pension will be reduced even if the cost of their exit is below the £95,000 exit payment cap. The member would have the choice to give up their statutory redundancy pay in exchange for an unreduced pension. In a small number of cases, discretionary compensation will be more than the strain cost. This is most likely to happen for an older employee or for those who join the pension scheme later in their career. These employees will be entitled to an additional cash payment, meaning the total cost to the employer equals what the total discretionary compensation would have been. The proposed changes will remove the requirement for a member to take their pension immediately if they're made redundant over age 55. If they want to take their pension immediately, they will need to elect to do so under option 1 that I just went through. Under option 2, the employee chooses a deferred LGPS pension, which they can take at any time between age 55 and 75, statutory redundancy pay plus discretionary compensation subject to the new limits I covered earlier. If the member takes this option, there will be no employer strain cost because the pension is being fully reduced to reflect because the deferred pension, they're not getting preferential reduced pension. Option 3 is exactly the same as option 2, except instead of opting for a deferred pension, the member receives a fully reduced pension, and again, no employer strain cost. Turning to the more complicated exits where the cost would exceed £95,000. In this case, the strain cost paid by the employer to the administering authority has been reduced because of the exit payment cap. Again, the member has 3 options. Under option 1, the member receives statutory redundancy pay, partially reduced pension. Essentially, it's reduced to the extent that the total cost, that is the strain cost plus the stat redundancy, is £95,000. The member then has the option to pay extra to the administering authority in exchange for either an unreduced pension or if they don't want to pay the full amount, so that a lower reduction would apply to their pension benefits. Options 2 and 3 are exactly the same as they were for members who are not capped. So if the member decides to give up their right to an immediate pension, then they would receive statutory redundancy pay, discretionary compensation subject to the new limits, and either a deferred LGPS pension to take later or immediate payment of a fully reduced pension. It's important to notice here that, as currently drafted, MHCLG is proposing that an employer would be responsible for informing the member of options 1, 2 and 3. So not the administering authority, not the pensions experts, but the employer would need to set out the member's options to have under option 1, stat redundancy pay and an immediate partially reduced pension. Option 2, stat redundancy pay, discretionary compensation and deferred benefits. Or option 3, stat redundancy pay, discretionary compensation and an immediate fully reduced pension. Those members who choose option 1 would also be able to choose to pay extra, but it would be down to the administering authority to offer them that option. It's important also to note that MHCLG is currently considering responses to the consultation. The final regulations may be different from the draft regulations that we can see now and that I've covered today. Based on the current wording of the draft regulations, the LGA has several concerns they've raised with the Ministry. There is no option to waive these further reforms as there is with the cap. So, for example, the exit payment cap can be waived on hardship grounds, but at the moment, the strain cost would still be reduced based on statutory redundancy pay. There is no option to waive that. Reducing the strain cost by the stat redundancy pay is complex and it will disproportionately affect the low paid and part-time employees. The communications exercise will present a significant challenge both for employers and for administering authorities. Most employees find pensions very difficult to understand already. This is not going to help. We know that pension software firms will not be able to change their systems in advance of these regulations coming into force. So for some considerable period of months, administrative authorities will need to perform manual calculations until those systems are updated. This is likely to lead to delays in providing strain cost figures that employers request that they will need to process the redundancy case. The current process, when a member is made redundant over age 55, will be made much more complex than it is now when these changes come into force. There'll be significantly more interaction between the employer and administrating authority, which could also lead to delays in the process and delays in actually getting to the point where you can make payments to the employee. On that cheery note, I will hand back to Sarah for some more of your questions.
Thank you so much, Rachel. Just putting my camera back on so that I can, you missed me scribbling furiously trying to take everything out of the Q&A box and make sure that we've picked up as much as we can. So what we will do now is we'll bring back in Phil Bundy and Jeff Histon, and we will do our best to run through in the last bit of time that we've got. So I'm going to start, and by the way, congratulations all of you in the Q&A box, because you've given us a nice spread across all of the various schemes and issues, so that's brilliant. I'm going to start with schools. So Phil, I think I'm coming to you with this. There's a question from a multi-academy trust about whether or not they should delay a restructure, but also the follow-up question really is for Jeff, in terms of if we got any idea on how long it might be that there could be decisions reached on waivers. So Jeff, Phil, if I come to you first and then Jeff for the follow-on.
I suppose the question of whether you delay a restructure comes down to whether really you can take into account, you know, the position on the ground. When we're looking at it purely from the exit pay reforms perspective, then yes, if you can delay, it's a good idea, because there's so much uncertainty out there. You've got the judicial reviews, etc. But you know, there are so many other factors to take into account when you're looking at a restructure.
Yeah, and in terms of how long it might take, we've had nothing yet from DfE in terms of their process, but if you look at what MHCLG are proposing, they're saying it could take up to 28 days to get a decision on a waiver. We can't imagine it would be quicker for DfE, so I would assume it's going to be along those same kind of lines. We will be raising with both of them, both DfE and MHCLG and Home Office as well, this timescale, especially as it's never going to be as simple as being able to do things in the right order with the right amount of time. So what's going to happen, for example, if somebody's already left by the time that the waiver is actually being granted?
Yeah, it definitely continues to be an interesting and complex situation. Thank you both for that. I've got an eye on the time, but we're going to plough through this batch of questions. So Phil, I'm going to ask you to comment on the question about what happens if an employer and an employee disagree about whether or not a discretionary waiver should apply.
Presumably the question is whether the employer should apply for the discretionary waiver. And it's the employer's decision whether to apply for that waiver. So ultimately they can say no. A word of warning though, if an employer unreasonably refused to apply for a waiver, and the employee could sort of say, well, actually you're in fundamental breach of contract, or you know, they might argue it's linked to discrimination or something like that. So if you are going to refuse to apply for a waiver, be absolutely clear why you are making that refusal.
Okay, those are wise words. And while you are there, Phil, will payment in lieu of notice be included in the cap?
Basically, the regs provide that up to 1/4 of the relevant person's annual salary isn't included when you're looking at pay in lieu of notice. So as long as you're only paying up to 3 months pay in lieu of notice, it won't be included in the cap. But if you were paying, say, 6 months pay in lieu of notice, 3 months of that would go towards the 95k.
Okay, thank you for that. Jeff, I've got a little batch for you coming up next. The first one is about a cash alternative. Is a cash alternative still a payment relating to an exit and therefore subject to the cap?
That's an easy one, yes.
There you go.
So any cash alternative must be, and everything you pay, including a cash alternative, whatever it is, if it's listed in Reg 5, must in total not be more than 95,000.
That's lovely. I hope you're not feeling too comfortable, because I'm going to throw a few fire questions at you now just to make up for the relative ease with which you answered that one. I hope I've jotted these down correctly. I'm going to just try and put them together. So you've been asked there, obviously there are separate pension schemes, but just to confirm that the cap still applies. There are exemptions for the fire pension schemes, but are there any substantial impacts that you might be able to comment on? And there was a question as well I haven't written down about summarising really how the fire pension schemes are impacted. Are you okay to comment on some of that?
Yeah, I mean, fire will be less impacted than the other schemes and the other employers throughout this, mainly because I'll refer you back to the regulations. So the exit cap regulations, regulation 6 includes all the exemptions, and there's a big chunk in there about fire payments. Okay, so quite a lot of what would normally be paid under fire is exempt. However, as an employer, you're still subject to the cap. The cap still includes phrases like "and any other payment relating to that exit." So you need to go through and make sure, taking into account the exemptions that are in there, what else are you paying and would they count towards the cap?
That's brilliant. Thank you for that. And I can see our excellent colleague Claire Hayes in the chat as well, trying to pick up some questions and answer some of that. So there's more in there. We've just run over time, but I'm going to ask Phil just to pick up, I think, which will be the last question of this webinar, about whether or not employers should be offering to fund some independent financial advice for employees in the same way that we might pay for or would pay for legal advice on settlement agreements. Phil.
I suppose the short answer to that is there is certainly no need to do it. If you wanted to do it, you could do it, but you'd have to make it absolutely clear that any advice that advisor gave was the advisor's advice, not yours. I think at the end of the day, this just shows, how complex this will be for many employees about deciding, what they want to do in terms of cash alternative payments and all the rest of that. So from an employer's perspective as well, you need to be careful that you don't stray into sort of, giving financial advice as well. So you just need to be careful about that.
Can I just quickly come in on that one, Sarah? Because there are lots of options now for people in pension schemes. And it's getting more and more and more complicated. We've already had freedom of choice. We've got annual allowance, lifetime allowance, all of these these are now going to be added in. What we are doing is we're having conversations across administering authorities to see whether, as a group of local authority, administering authorities or employers, we could see whether we could put together some kind of offer for financial advice. One of the reasons why we've changed on this is because claims management companies are getting very eager to get into this market at the point in time and try to prove that individuals has not been given the relevant information in order to give a good consideration and then make the wrong choice. We know that people will make the wrong choice. We need to make sure they've had all the information they absolutely need before they make that choice.
I think that's a really great way to summarise and bring this all together, Jeff. So we'll leave it there. Thank you all so much for your questions and your contributions today. I hope that you feel that we've managed to give you a real whistle-stop tour of exactly where we are and exactly where there are still issues of complexity that need a bit more detail on, and we will continue to update our website and our information and keep you across that as it develops. I think it's worth me just saying that we have pressed the record button on this webinar. I saw a couple of people asking in the Q&A whether or not that would be available. We will endeavour to make that available to those of you who have joined us today, to participants, but we need to ask you to bear with us on that. That takes technically and logistically a little more time and complexity, not as much as doing MHCLG regulations, but nevertheless, we're going to need a couple of days. So bear with us on that, but we will get that to you. And the slides go up on the LGA website, as I've said. Do keep an eye on the LGA events pages of our website, because there are always interesting webinars being organised now by the LGA, always worth tuning into, and loads of really interesting subjects coming up. So it's a really good way to keep in touch and across the latest issues. I just wanted to very quickly say thank you to all of our speakers. You've heard today from Naomi Cook, the head of workforce. You've heard from Jackie Wood and Rachel Abbey, our pensions advisors. You heard from Jeff Houston, the head of pensions, and you heard from Phil Bundy, from the Employment Relations Unit. I'm Sarah Ward from Workforce. I want to thank you all very much indeed for joining us. It was brilliant to have your company and your questions, and do keep in touch with us. That's how we keep on producing stuff and asking the right questions. Just leaves it now to me to say thank you all again for joining us, and I wish you all a very safe and peaceful Christmas. Take care. Thanks again. Bye now.